All right. The chair hereby calls to order the November 20th, 2024 meeting of the Kansas Governmental Ethics Commission. Thank you everyone for your attendance today. In your materials, you have today's agenda and the minutes from our meeting on October 23rd. If everyone has had a chance to review, can anyone identify any corrections that need to be made to either?
To which, the agenda or the minutes?
Yeah.
For the agenda, I would like to add an item if we may.
Yes.
As a first item, I'd like to add an executive session or a closed meeting for discussion of non-elected personnel matter exception issues.
Yes, got it. Noted. We will add that and we will begin today's meeting with that session. Any other corrections, additions, any mistakes anyone could spot? If not, I will take a motion to approve the agenda as amended by Commissioner Berger.
So moved.
Do I have a second?
Seconded.
Motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion to approve the agenda as amended and minutes from our prior meeting signify by saying aye.
Aye.
You didn't say the minutes. I wasn't here last time, so I really can't make that motion.
Okay, well, we're just reviewing them for integrity, grammatical mistakes. So I believe everyone voted aye. Any nays? All right, the motion passes. So given your agenda item, Commissioner Berger.
I would move that the commission recess this open meeting to discuss personnel matters involving state employees pursuant to the non-elected personnel matter exception, KSA 75-4319B1. The justification of the executive session is to protect employee privacy, and the meeting shall be resumed here at 15 minutes. Shall we say 1:20?
It'd be just
Sure, 1:20.
Just
Do I have a second?
second.
Motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion signify by saying aye.
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 All opposed say nay. Motion passes. Let us know when we're ready, Director Skoglund.
should be good.
Okay, returning to open session, I would just like to make the remark that the commission would respectfully request a placeholder for general counsel updates on future agendas, particularly with maybe a focus on litigation updates for any ongoing litigation. And I don't know if any other commissioners wish to kind of expound on that further. But I think coming out of our prior meeting, we had an expectation that we would receive litigation updates for the ongoing litigation. And I think we would like to receive an update of some kind on just what is happening. I don't know that anything necessarily has happened since we last met, but what is the current state of litigation at this moment?
Commissioner, the intent was that that be discussed in executive session under attorney-client privilege.
The only reason it didn't happen at the last meeting is we ran out of time with how long the hearing was.
Sure.
Well, how do we?
There is a placeholder for executive session.
How do we get into executive session to discuss that?
We have the motion.
It's on the agenda already
And it's on the agenda.
for attorney-client discussions regarding litigation.
So,
Okay. As requested, it is on every meeting agenda at this point.
Okay.
And just as a point of kind of emphasis on it, that as part of that, there is specific direction that is requested of the commission as to strategies and policy positions that are being taken in the litigation.
Yeah, so we can, I guess, table that until we get to executive session. I did not see that in the materials that I received. But any other commissioners wish to make any comments before we move on with discussion of the advisory opinion as the next item on the agenda?
I would like to have an executive session with our council, Mr. Chairman.
It is on the agenda already.
It is, okay.
Yes.
All right.
Now you can move it around as you see fit, but it is on the
Well,
agenda.
It's fresh in our minds. Which motion do we use?
This may not be a great time because we have
Scheduled hearings.
joining
Okay.
the meeting,
for hearing.
and frankly, you can have someone standing here and kicking them out as they come in, but that may not be the best idea.
All right.
We'll table
wait
it.
On the agenda.
Okay.
We will
Yeah.
definitely make sure we get to it.
Okay,
And then just a procedural question. I note that when we opened the doors, all council were standing at the door. Can you hear our conversation?
No.
No.
We were here because we thought it was close to two.
Yeah.
Thank you.
We normally even clear out the area right in front of the doors. People only are allowed over there when there's like a minute left. Yeah. So
okay, wonderful. The next item on the agenda is the advisory opinion. Caitlin, do you want to speak to this?
Yes, absolutely. So I will keep this as efficient as possible, as this advisory opinion, in contrast to the two prior that we had received, is fairly straightforward. Rather than asking a hyper-specific factual question on and if it complies, this individual requested just the commission update a previously issued opinion that was issued in the 2000s that addressed this exact question before. The person requesting just wanted an update and had a little wrinkle on ownership of a property interest into oil and gas wells. The length of the opinion is primarily just block quotes of the statutes. You'll notice the actual analysis and explanation is fairly succinct, again, because we're just advising this individual they haven't created a business yet, but they would like to. In short, they are a Kansas Corporation Commission employee who's a professional geologist who wants to open their own prospecting business while working for the KCC and wants to know if they can do that. And they also want to know if there is a prohibition on their business owning an overriding royalty interest in the oil and gas wells owned by the entities that he contracts with. Again, this has largely been answered in a prior opinion. His second question about the overriding royalty interest is what is new. And the statutes that were addressed in the prior opinion, that is referenced both in the opinion, it's advisory opinion 2001-09, and the requester acknowledged that his question was largely the same, just with the wrinkle of the overriding royalty interest. I don't want to get into the depths because it's way out of my understanding of the depths of oil and gas law and mineral interests and all things like that. But the requester makes it easy, and that he presented a formula in his request for an opinion to calculate what the interest would be that he is receiving in each of these. So at the forefront, it is pretty much he wants to know, what statutes do I need to be aware of to prevent any violation of the conflict of interest laws, as his first question. And so that's why there's just a lot of block statutory citation explaining, here's how you comply with the statute generally, and as long as you don't violate the statute, there's not a conflict. And so I just wanted to start at the forefront. I think Commissioner Ramirez did an excellent job the last time we had an opinion of making sure that we first, do we agree to the answer to both questions that he has presented, which is that, so first, that there is not an inherent conflict by him just creating the business, so long as he complies with the prohibitions. And to the second question, it is, again, not inherently prohibited that his business have an economic interest, this royalty interest, but it means that he would have a substantial interest in every single business that his business contracted with, which again, goes back to the general statutes about regulating conduct between state employees and an entity that they have a substantial interest in. So I tried to be as succinct as I could. I have a Word version in front of me to track changes and make them as we go through. I just wanted to first make sure that we are of the same mind of the answer to the question, and then guide our cleaning up from there.
3% overrunning royalty interest seems awfully high.
I hope that's his business decision.
Yeah, that's his position, so,
We're not providing an opinion on whether it's a good idea.
yeah.
For either side.
With that, I'll move that we adopt the opinion.
Second.
I like to have discussion on it.
Oh, okay. You can.
Sure, the motion has been seconded. Commissioner Berger, what do you think in reading the opinion?
So it's a new area for me. I'm not going to tell you that I am now up to speed, certainly in oil and gas, certainly on the KCC, certainly in the staff of the KCC, what they do, or even 46-233. I would just note, two issues for it. First one is if there's already an opinion out there and there's not been a change in the statute since then, we should probably just say there's no change in our opinion. Just as a practical effect. And then secondly, assuming that we even know what this individual does, I guess what I'm saying is I don't know.
Well, I might be able to provide some context here. So basically, this opinion, you're right, echoes in a lot of ways the original opinion, and to that extent, we are just saying this is that opinion stands.
I don't see that there's any harm in repeating what's already out there.
Well, I think the point is valid, but I think the reason why they're asking for an opinion here is because the last opinion did not address the overriding royalty interest.
Well, that's a different issue.
Which does create a substantial interest if you receive fees in excess of $500 from that entity. And so that's what this opinion is really focused on, is basically using that opinion and saying, how does it apply now that we do have a substantial interest in some of these companies, which you did not have in the original?
Well, a substantial interest from my thumbnail of research also includes just a 5% interest in the entity.
Correct.
So he has a substantial interest, even if it has no income, because it's any of the above.
He would need an ownership interest. So he has a substantial interest in his business, but the entities he's contracting with that he's receiving the 5% from, he doesn't have an ownership interest in them, but he is receiving money from.
Isn't the question though, whether or not the entity that he owns at least 5% of creates a conflict with his role as someone who reviews and approves wells and testings and things of that nature?
That I think is the original opinion, right? That's more or less what the 2000s era opinion kind of discussed, is a very similar scenario.
And rather than have to get into the ins and outs of what an individual of his role within the KCC does or could interact with a company that he has a substantial interest in, why wouldn't we just say there's been no change in the statute and we affirm the prior opinion?
That's not the request they have, though.
Well, that's the first part of it. So then there's a second part, right?
May I speak? So my issue is that we have specific facts that were presented, and I don't have the request with the fact specific and the jobs and stuff that the original requester from 2001 had. I'm working off of the facts and the job duties and his business as he has presented it to us. And that's why, yes, it largely echoes that opinion, but is why I felt the need to still walk through it, because he's presented us with yes, it's not as hyper specific as our other opinions, but I am not sure what the request looked like in 2001-09.
And that's where it comes from my second kind of big issue, which is for an advisory opinion to be useful. I feel like we should give clarity so that a person going forward, certainly this individual and then related persons who also can rely on it, know where that kind of, demarcation is.
I guess
at the end of the day, all we're saying is if you do something wrong, you may violate.
That's what he's asking, though, is what are the wrongs that I could do? And that's what he's asking. He's asking very generally, what are the possible harms that could appear from me creating this business? And again, we are including that context you're discussing of saying these were the facts that were presented to the commission in considering generally if creating this type of business creates a conflict. And we don't have that level of factual discussion in that 2001 opinion.
So maybe to couple up with Commissioner Berger's point, I was trying to read through this statute 46-254 and how we're to provide interpretation of the act versus necessarily making rulings on facts that are presented to us. And so my presumption a little bit with requests that come through on these opinions is someone would provide us a law or a statute. And then if there's confusion in that law or statute, not necessarily applying their facts, but providing what we understand it to be saying if there's confusion in it. Because otherwise, the opinion feels a little bit like they've engaged us as counsel to read the statutes for them and provide them an extensive legal advice rather than just interpreting a specific statute. I'm trying to limit the breadth of some of these opinions that we provide so that it's not just a free legal counsel that comes through with anything in the statute where we identify the laws. And maybe I'm overlooking how it came through.
I think that is somewhat of the point of our advisory opinions is to give that advice to the public. And that's similar as what the Attorney General does. They get very specific questions, or another example is the Attorney Disciplinary Advisory Board. They will get specific questions on if these things happen, how do we comply with the law? And I do think that the way that our advisory opinions are written, we also do all interested persons opinions, which are just no one asked the question, but the question's there and it needs to be handled. And so I think that folks are relying on us to give this guidance. And I do understand the concern about being overly broad. I just, if that is a concern with this opinion, I would like folks to specifically identify why it is overbroad, because I've done my best to make it specific to the facts and the business and the questions presented.
What's the interplay between the use of the term contract under 46-233 and a KCC employee who's involved in approving or closing down wells? Does that constitute a contract under the act?
The licensing aspect is addressed. That's 46-286, which is about licensure inspection. And if it's an organization where they hold a position, is the way that statute's drafted, and a position as the proprietor of the business, he would hold a position there.
Okay, so 286A shall not participate directly in the licensure, inspection, or administration or enforcement of any regulation of any outside organization which I see what you're saying, holds a position.
Yeah.
The position is interpreted as an officer position.
As far as we know, he's the only proprietor, period.
Right.
So he would be the only individual whatsoever.
So it's possible that he might be involved in approving wells that he would have a financial interest in.
He's not allowed to do that. That's the point of the second aspect of the advisory opinion as well.
It says you can't do that.
He can't do that. So if he does create that substantial interest, he cannot. Or hold the.
What you're saying to me makes sense to me, but when I read what our opinion is, I'm not sure that we're saying that.
Because you're saying, I see what you're saying.
Because we're saying if you're not directly involved in the licensure, and we're just reiterating what the statute says and providing clear guidance and not just some, almost feels like this is like, not only did you violate, but we gave you an opinion and now we got you. At the end of the day, we're not providing that clarity.
I think it does, and just in that last sentence before it goes to, you must ensure you are not directly involved in the licensure, inspection, or administration or enforcement or regulation of your business.
Right. So what's directly involved if he's necessary for the granting of a permit?
Do we
But-
know that he's necessary, or is there somebody else with his
I
job?
don't know that. That's the whole.
That's the reason for this guidance, is so that we
Right.
can know that somebody else needs to be involved. He didn't give us the details of, excuse me, every individual that's at the KCC.
I just, I want to just give any other commissioners, maybe Commissioner Harrison or Commissioner Jackson, an opportunity to just like have any weigh in. We've got a pretty solid agenda. I'd like to move on from this topic. We do have a motion that has been seconded. Unless we have any comments from any commissioners who have not yet raised any comments, I would suggest that we take a vote on the seconded motion.
No comments here. Thank you, Mr. Chairman.
Okay, well, all in favor of approving the seconded motion to approve the opinion as written, signify by saying aye.
Second Chairman, there was a typographical error that you wanted to correct. Is that correct?
Sure.
Okay, if there isn't, that's fine.
I don't think so.
Okay. So, and if on this motion, if everybody could raise their hand on the aye, I would appreciate it. All in favor of approving the motion signify by saying aye.
Hi.
Aye.
Commissioner Jackson, how did you vote?
I did not vote aye.
Okay. All in favor, all opposed, say nay.
Nay.
Okay.
So we have 3.
4-3 without your vote.
Okay. So is that enough to pass, or do we need 5?
You need
5.
5.
Okay, I will vote to approve. Returning to the agenda, we also have an executive director's report, beginning with the campaign finance update.
I'll be really, really quick. You have the campaign finance update. It's a page. You can see the number of failure to files that were sent. I appreciate all the work my staff did to get those numbers very low. It really was good, really good work to reduce the failure to file rate this cycle. So I'm very appreciative for all they do. I'll move on to the annual report unless someone has questions on campaign finance update.
Good.
Okay, we are statutorily required to provide an annual report in about 2 weeks to the legislature and the governor. So I'm just quickly going to go through a couple of things.
If I may interrupt, are there any changes from what you previously reported?
The legislative recommendations are entirely unchanged. There is not a single word that is different from from what was in the October meeting, and I don't think there were any changes between the October meeting and the annual report last year, if I remember correctly, other than the litigation note.
Correct.
This would need to be in the annual report. Will there be an opportunity to discuss things that you had in there, other
Yes.
transparency issues? I'd like to talk about transparency in one particular one, but I can wait. I mean,
It's an open meeting. I mean, I'm not saying we should not have any questions. I'm just trying to move my portion of it forward. If you have questions, we should hear them.
Mhm.
well, I mean, like one of the things is, and cleanup, on the cleanup section of it, there's illegible signatures everywhere. And I'm told that's in statute. Can you fix that thing that you either make it a regulation or just do it?
We're trying to promote e-filing, which will eliminate
Well,
that.
but just just signature, printed names for non-electronic filings.
I have an idea on how we can do that without legislation. I
Okay,
think
that's
we can
what
do that.
I've been looking for.
Yeah,
That's
so-
what I've been looking for.
Let's set this for the January meeting because we can just, we're going to double check to make sure we can do this, but we can approve a form change there. I don't think that requires legislation, and that should be pretty straightforward. We're just changing the form.
And then in your section 4 about closing those reports, sometimes there's significant amounts of money that's being shared. I don't think there's any good public records of that. We need more transparency on that. Is that a discussion for the future?
On the campaign account termination,
Yeah. When they
um,
terminate and they give $20,000 somewhere, there's a very little public, notice of that.
yeah, they have their report that they file, and we're actually in the process of updating our database, which will hopefully have a better public-facing interface, which means you'll be able to access on our website, not just current candidates.
Okay,
but all
because right
candidates.
now you don't have a good place for them.
That's
The
right.
Secretary of State has them, but as long as there's some place for them in the future, that's what I'm looking for.
I have the exact same concern, and we have a
Okay.
system in place that we're working on to address that.
And the final one, we need some, like in a verified statement with ActBlue, WinRed, Stripe, are we looking at anything for some sort of verified segment for all these electronic filings?
We can see what's done in other jurisdictions.
I mean, I'm looking for something equivalent to what the FEC is doing at the national level.
Yep. Yeah, I understand
That's
that.
just a suggestion, so.
The
No, that's
FEC isn't
helpful.
Doing anything like it.
No, we have, the FEC is doing full disclosure of all those people by record. We have no disclosure at all, except for the state and local people. So they have a lot more disclosure, these are electronic records. And, okay.
No, that's great. Those are all
Okay.
great points. Thank you very much.
Sorry, wasn't.
Not at all. So I'm gonna quickly just go over, we had, I'm gonna skip right to campaign finance since we're a little tight on time. We had over 1,500 receipts and expenditures reports filed in this fiscal year, and every single line of those reports receives a comprehensive desk review for compliance. So my staff is amazing. I'm very lucky to have the people that I do, and I appreciate all that they do. For all campaign finance across the entire election cycle from for the fiscal year, there were 114 failure to files issued on 1,500 reports, which is 7.5%, a little below normal, which is great. Error and omission notices, we had 241, which is 15.9%. That's about on target, a little lower than usual as well. So compliance appears to be going up. People can have lots of discussions about why they think that's happening, but that is something that's going on. On page 9, there were 6,433 statements of substantial interest filed. Mine and yours are in that number. On 10, there were 616 lobbyists representing 2,096 organizations so far this year, and they received across 5,520 reports that they filed, only 92 failure to files were issued, a 1.7% failure to file rate, which is excellent. Jessica White, our lobbyist coordinator, is excellent at working with them and making sure that they stay compliant. So far this year, they spent $1.3 million on lobbying, which is higher than normal. On enforcement, on page 11, we have 19 investigations that have been addressed in this fiscal year. 27 complaints were filed. 20 of them were dismissed because of either insufficient evidence to support a probable cause determination or after being set for hearing. Most of those are, we filed a complaint for someone who didn't file a report, and it was dismissed because they filed. 6 complaints had a public hearing, and 1 complaint is ongoing. We assessed $43,000 in civil penalties, waived just under $5,000 of that, collected $30,000. We assessed $49,000 in civil fines. Those go to the state general fund, not to our fee fund. As a reminder on the what I think is a good statutory change from a couple of years ago.
75% of our fines are actually collected.
That includes amounts from previous years. Now, again, these are civil penalties.
Rolling. Okay.
Yeah, so those numbers are interesting, but a lot of things end up in either we have to send repeated reminders and then it goes to collections eventually. But the state collection system is very effective. So, and then you have legislative recommendations, and I'll just note that there's a 10-year analysis of lobbying expenditures on the last page, on page, what's the numbered page 21, that I think is very interesting if you want to get into the weeds on what happens in lobbying year to year. So, any questions about the annual report? Sorry for the abbreviated presentation on it. I give a much longer one to the legislature.
Do we need to make a motion, Mr. Chairman?
Yeah, do any commissioners have any comments at all? Going once, going twice. Director Skoglund, do you believe we need a motion to approve, correct?
Yes, that's
okay.
correct.
Do any commissioners wish to make a motion to approve as written the annual report?
So moved.
Thank you, Commissioner Solbach. Do I have a second?
Second.
Okay, the motion has been seconded. If anyone has any comments, now's the time to raise them. Any
The only
reservations?
The only comment I have is I like the cleanup, but I can't tell you that that is everything necessarily that I think is necessary or will be useful. Kind of like what Commissioner Glenn is saying. There are other items out there I think that could be addressed, but this is at least a sampling.
Yeah.
I agree with that.
Perfectly fair. Well, the motion has been seconded. Let's go ahead and take a vote. All in favor of approving the motion to approve the annual report, signify by saying aye.
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 All opposed, say nay. The motion passes. The next item is a, well, general topics, procedural regulation subcommittee update.
I'll just report quickly that the subcommittee met. We're going to meet again. They are open meetings to which everyone is invited to at least watch. And we're working toward the very first step will be the conflict of interest rule, which is actually a far more complex issue than simply saying, make a rule on conflict of interest. Thank you.
I will also note briefly that just so it's on the live stream, we are seeking public comment suggestion regarding potential reforms to its procedural regulations. You can look on our website how to submit written public comments and suggestions to the commission for consideration by the subcommittee. Please submit that if you have any. Thank you.
Thank you.
Wonderful. Thank you both. The next item on the agenda is to just quickly note for the record, civil penalty assessments. Director Skoglund.
I'll just note that they're in you have the documents that show what they are for an amended July report, October report, and October PAC reports. That's it.
Got it. And the next item on the agenda is a civil penalty waiver request. We have one to consider from Ms. Nichols. Director Skoglund, do you want to give us some context here? I know everybody has in their materials the actual request. What's your position?
Yes, Ms. Nichols was assessed $300 on 3 different instances, once in January 2022, then January 2023, and again in January 2024, for a total of $900 of civil penalties, plus has a $5,000 fine that was imposed in June of 2022. You have all of that on page 45 of the open meeting materials. You have her writing on her explanation. I do not recommend this waiver. First, I'll note we can't waive a civil fine without a motion to reconsider the hearing. That time frame long expired. So we're only considering the $900 today in civil penalties. That request for waiver is also out of time. We have 30 days to submit it. And also I'll note that in July, she makes a comment that she had an attorney contact us. She thought everything was resolved. That was actually in July 2022, before 2 of the civil penalties were even resolved. You have my comment in the second paragraph under out of time about what we have a very good memo to the file about what actually happened on that phone call between Mr. Berry, our staff attorney, and Mr. Boone. Mr. Boone notably also noted that she knew she needed to update her address and never did. At any time she could have resigned in writing, did not do so. That would have gotten her out of any of these issues. We tried to we contacted her in many different ways. We even left a phone message. And nothing actually got filed until she received a collections letter in October of 2024. I understand that these issues are difficult. Treasurers have issues with candidates all the time. I don't see anything here that would justify a waiver.
So you're saying that there is contradictory information and evidence to what she has in her letter?
Yes, I would say that is accurate.
Okay. Well, do any commissioners wish to make a motion? If not, we will move on to the next item on the agenda.
We're on hearings after that.
Moving on, we have, I believe, 4 civil fine hearings on today's agenda. We have on the agenda, beginning with complaint number 788. I believe Commissioner Berger is the assigned hearing officer in this matter. Director Skoglund, any reason to handle these in any particular order outside of the way they're laid out on the agenda?
I think the agenda is well ordered.
Okay. Well, then with that, I will turn it over to Commissioner Berger.
Thank you. Thank you. I am Commissioner Christopher Berger. I've been appointed as a presiding officer in the matter of Patrick Schmidt, complaint number 788. As the respondent, I hereby call this hearing to order, and would the parties please enter their appearances, beginning with the complainant.
Sure.
Patrick Schmidt.
Complainant. sorry. Caitlin Bull Stewart on behalf of the complainant, Mark Skoglund, Executive Director. Mark Skoglund, Executive Director, appears as witness.
And Mr. Schmidt? Can you turn your camera on, please? You have it.
Yeah, I'm sorry. I guess I can pull over. Sorry. I thought we were going to be starting at 13:30.
Understood.
As long as he's at least on there, just, I mean, that's up to Commissioner Berger, but at least so she can, I have for his oath.
Did
Is that
Mr.
sufficient?
Schmidt his appearance?
Yes, he did.
Thanks for your time.
So this is a matter of a complaint hearing before the Kansas Governmental Ethics Commission. The hearing will be conducted according to the provisions of the Kansas Administrative Procedure Act. The applicable burden of proof is that affirmative findings of fact by the commission shall be based on clear and convincing evidence. Now, as I understand in this instance, there is an agreement between our complainant and our respondent.
Yes, that is correct. We have filed a proposed consent decree with the commission for its consideration. The consent decree functions as the replacement of the commission's report and order.
I want to note that the proposed consent decree and order is referencing that if the matter were to go to an evidentiary hearing, that clear and convincing evidence would be introduced to support a finding, and then it identifies a series of facts. Mr. Schmidt, do you agree that in fact there is, not just would be, but is clear and convincing evidence that you admit to that you are an individual residing in the state of Kansas?
Yes.
That you were a candidate for state senate in the 2024 election cycle?
Guilty.
You don't have to say guilty. You just have to tell us if you contested or no. That on May 9th of 2024, that the executive director sent a letter to you informing you that the paid for attribution was required for all internet communications, telephonic communications, mailed communications, and other media communications that expressly advocated for the nomination, election, or defeat of a clearly identified candidate for a state or local office.
Yes.
Do you also agree and stipulate that on May 9th, 2024, that letter further informed you that the commission is generally understanding of first-time disclaimer mistakes, and therefore the letter indicated that no complaint will be filed for the May 7th, 2024 paid for violation?
Correct.
And do you agree and stipulate that on or about July 2024, two other mailers were sent out by your campaign expressly advocating for your election as a clearly identified candidate for state office, but that neither mailer contained paid for attribution language?
Correct.
And that a total of 7,399 households were mailed, each of the mailers lacking the paid for attribution language?
Correct.
The section, I think we only have the old one that's online.
I'm sorry,
Do we?
I didn't, the other one was not filed. It was a discussion we wanted to have.
Okay. So I'm not sure exactly how to proceed. Do we want to go forward with?
No, he needs to, he hasn't been sworn in,
Oh, sorry, my apologies.
then we can ratify maybe.
Okay,
You saw him, correct?
yeah,
Okay,
but,
I think
I
you
guess we're
need
going
to
off
see him
script.
for the oath.
yeah, I did.
Yeah. Patrick, do you mind pulling over and turning on your video again so that our notary may take your oath? We apologize. That was an oversight on our part.
Yeah. No. We all make oversight mistakes, don't we? Sorry. Here I am.
Okay, you ready?
Yep, all right, can you raise your right hand, please?
I'll just say so.
You do solemnly swear, sincerely and truly declare and affirm that the testimony you shall give in the matter at issue shall be the truth, the whole truth, and nothing but the truth, and this you do under the pains and penalties of perjury?
I do.
And for all the questions that I asked you with regard to your stipulations, do you ratify and affirm the truthfulness of your previous answers?
I ratify and affirm the truthfulness of my previous answers.
Thank you. So,
You can put your hand down and continue.
yeah. So process-wise from here, Mr. Burris, do you have any suggestion as to a appropriate and expedient manner in which this particular respondent can have his full say and we can come to a conclusion?
Well, first of all, the question would be, did he violate the statutes? And
Okay, sorry, I was trying to expedite, sorry. So this hearing's being recorded. Therefore, responses to questions must be verbal, as the audio video recorder does not pick up on nods, unclear responses, and other gestures.
Mr. Chairman, if you want to move things along, I'll move that we adopt the consent order as the order of the commission.
Does anyone, is there a second to that? And is there any discussion or desire to have presentation of a proffer or additional evidence?
Second.
And have you read the order, John?
Yes.
There's a blank in the order.
Oh, that blanket's for a fine, isn't it?
Yes.
Yeah, we haven't taken up the fine yet.
Respectfully, Commissioner Solbach, this consent decree did agree to a fine amount. And the blank is if the commission accepts that fine amount to offer the reasoning for doing so.
Actually, my motion is only with respect to the violation of the statute.
Consent decree is fine for that.
And we'll deal with the fine later on.
I understand. I just want to make sure the motion's clear because the consent decree includes the agreed fine amount. So your motion is to adopt the consent decree absent the agreed upon fine amount.
That's correct.
So procedurally speaking, going forward, it really would be better if we could have a separate set of stipulations that could be approved and accepted. And then we have the evidentiary basis to make a determination of whether there's a violation or not, and then move into the penalty.
I guess I'm just a little confused because the point of the consent decree is to agree to liability. This is a settlement essentially, and I do understand the fine being separate. I do understand that.
Well, we can include the fine. What fine did you agree to?
$500 was agreed to by the parties.
Okay, I'll incorporate that into my motion for the whole thing. If my second will approve. Will my second?
I approve with the, hold on. But can we just edit that part to make it just that we accept the consent decree and leave out the explanation? So that we don't have this weird blank.
Oh,
Well, the commission needs to provide reasoning for why it has accepted.
No, I think, are you saying, Commissioner?
We're required
to strike that portion and that you would want to accept the $500?
Yes.
Yeah.
Oh,
Accept the consent decree.
okay.
Just flat out accept it with.
I see. Yes, we can delete the blank.
Delete the blank and second it.
We would also need to delete the following statements
Yes.
regarding the reasons for its acceptance.
Yeah.
Okay.
Exactly. So we have it moved to accept the consent decree at a $500 penalty. That would include the finding that there has been a violation and that the appropriate penalty is $500. And then deleting what will be conflicting provisions within that if we were, because we are not increasing the $500. That moved and seconded?
That's correct.
Any discussion? Hearing no discussion, all in favor say aye.
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 All opposed say nay. All right, it passes. Thank you very much.
May I
Yes.
have permission to make the edits for you, Commissioner Berger?
Yes, and
You need to close the hearing.
yes, well, I also need permission to sign it.
Mhm.
Say.
So if someone can make a motion that would authorize, I request authorization from the commission to have this drafted, to review and sign an order reflecting the findings and conclusions of the commission as a whole and cause it to be served upon the parties.
So moved. All second.
It's been moved and seconded. Any comment or any discussion? Hearing none, all in favor say aye.
Aye.
All opposed say nay. If the commission desires to recommend further action be taken by the appropriate prosecutor for any criminal liability associated with violations, the floor is open to such a motion.
The consent decree indicates that no further prosecution would be recommended.
Would be, okay, thank you.
Mhm.
And hearing no motion, that would remain. So the hearing in this matter is now closed and I return the meeting to the chair. Thank you.
Great. Thank you. Mr. Schmidt, you are welcome to stay on or you are free to leave. Thank you for your time today and thank you for your attendance. Returning to the agenda, the next item we have is complaint 784. I believe Commissioner Solbach is the assigned hearing officer in this matter. Is that correct?
Yes.
Yeah. Okay, so then I will turn it over to you, Commissioner Solbach.
Okay, my name is John Solbach. I've been appointed as presiding officer in this matter.
You want to sit here, John?
Complaint 784.
It's in materials, it's a Judge Barber.
I'll get it for you, John.
Mark Scoveland versus Mark Lang.
No,
It's Joshua Bargdill.
Okay. Thank you. I call this hearing to order. Would the parties please enter their appearance here?
Yes. Caitlin Bull Stewart on behalf of the complainant, Mark Skoglund, Executive Director. Mark Skoglund, Executive Director, also appears as witness if necessary.
Are there any other appearances?
Mr. Bargdill.
Yes.
Okay, can you state your appearance, please?
State your name.
Joshua Bargdill.
Okay, are you represented by counsel or you're appearing pro se?
No, sir, I'm not represented by counsel.
Okay. All right. This hearing will be conducted according to the provisions of the Kansas Administrative Procedure Act, and of course, the applicable burden of proof is by clear and convincing evidence. The hearing is being recorded, thus please make your responses audible so that the court can pick it up. And the complainant will now make an opening statement. The respondent can make an opening statement following hers, or you can hold yours until the close of the evidence. Go ahead.
Commissioner, in this instance, we also have a consent decree that both parties have agreed to and presented for your consideration. And Mr. Bargdill, obviously, before he offers his statements, he will need to be under oath. If we may do that before discussing the consent decree with your permission.
Sure.
Okay.
Would you administer the oath to the respondent?
all right, Mr. Bargdill, can you raise your right hand? Thank you. You do solemnly swear, sincerely and truly declare and affirm that the testimony you shall give in the matter at issue shall be the truth, the whole truth, and nothing but the truth. And this you shall do under the pains and penalties of perjury.
I do. Yes.
Okay, Caitlin, would you summarize the consent decree for us?
Absolutely. So this consent decree is even easier for us to calculate than the other because this is a matter of a campaign. Mr. Bargdill was treasurer for Mark Lamas, was a candidate for Harvey County treasurer in the 2024 election cycle. The July 29th receipts and expenditures report was not filed on the day that it was due. It has been filed since then. It was filed on or about September 20th. However, the commission has the new election sensitive guidance document that was enacted in November of 2023, and we've given you all a copy as well. That states that a complaint shall not be dismissed if it is election sensitive just because it was filed. Mr. Bargdill has had access to that document. He can attest to that as well if he's seen it. And we essentially just agreed that they did file it late. They have since been compliant and they agreed to a fine calculation of $155, which is based off of the formula, which is $100 plus 5% of the contributions received.
Did they also have an agreement with respect to recommendation for further prosecution?
Yes, we also recommended, we agreed to not seek any further prosecution.
Mr. Bargdale,
Yes,
do
sir.
you agree with that summary of the agreement that you made?
I do. Yes.
Okay. Is there a motion to adopt the agreement?
I move to adopt the consent agreement, but again, with the edit of number 8 to remove the following statement regarding the reasons, so just accepting the rest of it without adding explanation.
Second,
Is there a second?
second.
Moved and seconded, any discussion? No discussion, all in favor, please signify by saying aye.
Aye.
Opposed? Motion carries. Is that all we have to do here?
May I request your permission to finalize the order and present to you for signature?
Yeah, is there a motion to that effect?
So moved.
And I would add to it.
The authority.
Yeah, the authority.
We're getting it?
Been moved and seconded, all in favor signify by saying aye.
Aye.
Opposed?
Aye.
Motion carries. That concludes this hearing. This hearing is now closed. Mr. Chairman.
Thank you, Commissioner Solbach. Mr. Bargdill, thank you again for your attendance. Again, you are also welcome to stay or you are welcome to leave, but we appreciate you joining us today.
Could I just say thank you for your time and my apologies for not taking care of this in a timely manner. I appreciate the commission's work and appreciate all of the guidance and help that I've been given. Thank you.
Great. Thank you.
Thank you.
The next complaint hearing that we have on the agenda is complaint 786 and 787 involving a Christopher Parisho, and I believe Commissioner Glenn is the assigned hearing officer in this matter. Do I have that correct?
There's two respondents.
He said both.
Oh, he said both, like, okay.
Oh,
Yes.
we only said
I
one.
only heard him say one. Oh, he did? Okay. I missed it.
Oh yeah, Christopher Parisho and Melissa Stout. Commissioner Glenn, I turn it over to you.
Thank you. So my name is Earl Glenn. I've been appointed the presiding officer before the Kansas Governmental Ethics Commission in this matter of Mark Skogland, Executive Director of the Commission versus respondents Christopher Parisho in complaint 786 and Melissa Stout in complaint 787. I hereby call this hearing to order. Would the parties please enter their appearances, beginning with the complainant?
Yes, Kate Wimple Stewart appears on behalf of the complainant, Mark Skogland, the executive director. Mark Skogland, executive director, also appears as witness.
And can Mr. Parisho and Ms. Stout open your video maybe and enter your appearances?
I am on the phone, so I'm not able to do any video. I had to call in because Teams wasn't working for me.
They'll have to be sworn. I don't think it's gonna be a testimony.
He doesn't give any testimony.
Well, they have two of them. They could ask each other.
We can't get him under oath. That was the issue without her being able to see and identify.
I speak on the phone before.
The,
And I'm Melissa Stout. I'm having trouble with it. I can't get it to do the reverse camera, so I have to look in the mirror to do it.
We want to continue to try and get this fixed out, figured out. Don't really want to.
she's on the camera. I think that she's doing great.
Okay.
And the reversal, I don't think is that doesn't matter on our end.
Okay, well,
That's
let's see.
common.
We just can't take testimony from Mr. Parisho.
Well, that's up to him, whether he intends to give testimony or not.
Yeah,
You can do a proffer then, yeah.
Which
Yeah.
He's a respondent, but he's not someone who's gonna be giving testimony here.
that's true. So, okay, I think we're okay.
Well, I think it's up to him. But if he needs the opportunity to be able to give testimony if he wants to.
It's up to Mr. Parisho, because our statutes required that he be under oath, and according to the notary statutes, she has to be able to see him to take him under oath, which means if he can sit here and witness the hearing, but he can't offer testimony unless he is sworn in.
But we can swear in Melissa though.
We can swear in Melissa because, well, actually we can't, because we have to swear in Parisho to identify her, because her driver's license didn't come through.
Yeah, it wouldn't open up for them.
She's just said it wouldn't open up.
I mean, I can try to invite him directly on a,
Okay,
if he doesn't
I
email
don't
us.
have the app. That I think might be the issue, is the fact that I don't have the app.
your phone with.
Yeah, you have to download the app, Chris.
You can do it either way, but the app is easier.
Mr. Parisho, we might try and directly send you an invite to see if that helps.
That's fine with me. Any way to try and make it work.
Okay.
What's your email address, sir?
Christopher.Parisho, as it's spelled in all the documents, at gmail.com.
Sir, yeah, that's
Okay, we will try that.
sorry, I haven't do it.
Do I need to hang up the phone before I try the invite?
One moment.
Yeah, we've already sent him the link through.
Yeah.
So this isn't gonna be any different. We can move on to Lomas and come back to this if he, and give him an opportunity to try to fix his video.
Okay.
But that's the only thing I can think of at this point.
Okay.
So we have to hold this to see if we can fix his video, but that's again.
Yeah, we have another hearing. We could move in the interim to give him a chance to see.
What do I formally do?
Yeah.
Open the hearing is the.
Yeah, we'd have to continue it.
Yeah, I have to.
After.
And what's the mechanism for
My,
that?
my issue is I can't attend later. I gotta go get my grandkids.
We won't just continue for January.
I think we need to continue this hearing then. I would request a continuance, until the January meeting. So that we can get all this technology and stuff figured out. We've already submitted our exhibits and everything like that. We would just be continuing the hearing, until the January 22nd, 2024 commission meeting at 1:30 p.m.
Mr. Glenn, I'll move. Continue.
Is there a second for the continuation?
Second.
So all in favor of continuing till January?
Aye.
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 All opposed? So we'll continue this in January. We'll hopefully work out these details, technical details that are done.
Yes, we'll reach out to both of you after this meeting and we will
Good
try
job.
and get this done as quickly as possible.
We'll run some tests.
We apologize and appreciate your patience.
Send
Sorry.
mine by PDF, my
No problem.
ID.
Sorry that it didn't work.
Fine.
Sorry about that, everybody.
Then.
Okay, yep. Appreciate everyone's patience with that. Technology is fun. Does it go back to the Commissioner Harold?
Oh, yes, the meeting goes
Chairman?
back to Chairman Hale.
I'm sorry, I had to step away, just for a moment.
We continue that hearing until January, and so
Okay.
the ball in your court now.
Got it. Returning to the agenda, the next item we have is complaint 785, Mark Lamas, and I believe Commissioner Solbach is the assigned hearing officer in this matter. Do we have Mr. Lamas in attendance? I don't believe so.
I'll poke my head out, but I'm gonna say no. He's not in the room. He's not on the camera. He is not present.
Okay. Well, Commissioner Solbach, I'll turn it over to you to just handle.
Okay, my name is John Solbach. I've been appointed as the presiding officer in this matter. In the case of complaint number 785, Mark Scoblin versus Mark Lamas. I hereby call this hearing to order and ask the parties to state their appearances, please.
Caitlin Bull Stewart appears on behalf of the complainant, Mark Scoglin, Executive Director, and Mark Scoglin, the Executive Director, appears as witness.
Okay. Are there any other appearances? Okay,
And I'll just note, Commissioner Scoglin looked out in the hallway as well. Or did you?
Counsel
Council.
Oh, sorry.
walked in the hallway.
A movement behind me.
there are
And then
no
it went
other
I got promoted to
appearances.
commissioner militarily though.
Is there a consent order in
Director.
this case?
There is not, we have not been able to get a hold of the respondent. However, I did submit proposed findings of fact and a proposed commission report and order for consideration.
All right.
And counsel, do I note that also he failed to appear at the pre-hearing?
Correct. Mark Lamas also failed to appear at the pre-hearing conference.
Would you like to present the evidence by proffer?
Yes, please.
And I don't think we need to swear Mr. Scoglin if you can present his evidence by proffer as well.
Yes, absolutely.
So please proceed.
Thank you. Mark Lamas was a candidate for Harvey County Treasurer in the 2024 election cycle. We just spoke with his treasurer a little bit ago. This was the issue of the July 29th, 2024 receipts and expenditure report. Was not filed by the deadline. It has since been filed by the treasurer. It was filed in September. This would constitute one campaign finance violation for Mr. Lamas for failure to file the July report by the deadline. Additionally, the commission's election sensitive guidance document that was referred to earlier guides the fine that is appropriate for this report. As Commissioner Solbach has pointed out, the presiding member, I will be offering the director's evidence through a proffer. And as a candidate for office under the Campaign Finance Act, Mr. Lamas subjected himself to the subject matter of the jurisdiction of the commission. He is also a resident of the state of Kansas, thus personal jurisdiction is proper. Service was also proper in this case. It was made to Mr. Lamas at his address listed on his appointment of treasurer or candidate committee form for candidate or local office. First class mail was never returned, and notably, Mr. Lamas did sign the return receipt for the notice of public hearing, which includes the entirety of the administrative record. Under KSA 254152, both the treasurer and candidate are responsible for any reports that were not filed by the report deadline. This report was not filed by the deadline. The candidate is responsible for the failure to file that report. And this is a fairly clear-cut case, especially considering that the candidate is in default in this instance. In this case, even a higher burden of proof than that which is required of us is met because objectively, the report was not filed on time. It was filed in September. So this is a clear-cut case of failure to file when obligated to do so. We've done everything that we can to communicate to Mr. Lamas. Staff has provided the appropriate failure to file notifications. And because this is an election sensitive report, if the commission does determine liability, we have a calculation to get to the fine amount as well. But I did think just very succinctly, the executive director's request is that the commission find Mr. Mark Lamas as candidate for Harvey County Treasurer liable under the Campaign Finance Act for failure to file the July 29th, 2024 receipts and expenditures report by the requisite deadline.
And if you called all of your witnesses and placed them on the road, they would testify to those things.
Yes, all of the witnesses, if I had called the witnesses, they would have attested under oath to the information that I have provided to the commission via proffer.
Okay, what is the fine amount that you calculate?
The fine amount would be $155. And if the commissioners would like to look at the report, because this is a local level report, it is not available electronically. So I have a copy of that report if you all would like to look at it. Again, the formula is calculated via, not just, we're not, I guess I technically need to introduce this as an exhibit. So I have the July report. May I introduce this and please have it marked as Complainant's Exhibit 1?
Is there objection? Seeing none, it will be admitted.
Thank you. In the report, as you can see, this is a local level report. They're not available online. The formula is calculated based on contributions. It's $100 plus 5% of total contributions received just how we've gotten to the $155 number for the fine.
Okay. Do we have a copy of the proposed findings of fact and conclusions of law?
They should have been, they were included with the, materials.
Okay. Is there a motion to adopt the proposed findings of fact and conclusions of law?
May I ask a question first?
Yes. Well, you can ask the question first or afterwards.
So the information that has been proffered, that's the same information that's been submitted under oath for probable cause and sufficiency determinations?
Yeah, absolutely.
And Mr. Bargdill
Yes,
was the actual treasurer for this individual?
that's correct.
Kind of same individual who just consented and
That is correct.
stipulated all the same facts.
That is correct.
The same case, basically.
Exactly.
Is there a motion to adopt the proposed findings of fact and conclusions of law and order?
I would move that we adopt it with the default language.
Okay. Is there a second?
Second.
Moved and seconded, it's further discussion. Favor, please signify by saying aye.
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 And, is the commission desire to recommend, something with respect to prosecution or non-prosecution? Yay. Is there anything else I need to cover?
We would need a motion to give me approval to, draft the final version of the report and order and you permission to review and sign on behalf of the commission.
Such a motion.
So moved.
Second.
Discussion,
All the stare at each other.
all in favor, please signify by saying aye.
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 Thank you, Mr. Chairman,
Hope return.
and, return to the chairman.
Yes. Thank you very much, Commissioner Solbach, Commissioner Berger, Commissioner Glenn. It's greatly appreciated. Moving on from the hearings, the next item we have is the executive session. Director Skoglund, I currently have 2:24. How much time do we need?
Not a lot to talk about. It's up to you. I know that you may, I don't know how many questions or anything else that you may have at this point.
The purpose
What-
of the session.
Why don't we
This is-
say? Go ahead.
Based on our previous conversation, I would say we need a little bit of extra time.
Say 20 minutes?
Yeah.
Joel, think?
Yes.
Let's
wanna
say 2:40. Is that fair?
Yeah, that's good.
Let's say 2:40. Can anyone have the motions handy? Can
Which one, what do you need? Recess?
On the litigation,
Executive.
not the recess.
Executive, motion for executive session?
Yep.
I move that the commission recess the open meeting to executive session with Office Manager Paige Quintana Paget, Executive Director Mark Skoglund, General Counsel Caitlin Bull Stewart, and Conflict Counsel Jesse Burris present to discuss matters related to sealed state district court litigation and for good cause as provided by KER 1962. Justification for executive session is so the commission can consult with its attorney regarding matters that would be deemed privileged in the attorney-client relationship as contemplated by KSA 75-4319 B2. The open meeting shall resume here at 2:40.
Perfect.
Do I have a second? Motion has been seconded. Any additional discussion? Hearing none. All in favor of approving the motion to enter into executive session signify by saying aye.
Aye.
All opposed, say nay.
All right, stream is live.
Okay, returning to open session, the next item we have is recessed session, and Director Skoglund, do you have a sense of time? It is currently 2:40. How much time do we need?
I think this is to review all of the
The normal recess matters.
right.
25 minutes, you think? I mean,
Well-
One open session matter before we get into that.
sure.
What's the current status of the public criminal action with regard to Mr. Watkins?
It's publicly available on the portal. I'm not sure how much we can comment that at the moment.
Because
There are pleadings presented for
steps.
things that.
Well, I wasn't revealing that. My question was the public criminal, is it still proceeding? Is it not proceeding? Is, it is.
Let's go recess.
That seems, yeah, I was gonna say, I don't want this to open.
Okay, so I have 2:42 right now. Can we say 3:05?
It's then, but I don't think you'll have questions after the recess session.
3 or 5 good enough, Chris?
I think probably is.
3 or 5.
23 minutes.
Do I read it? I make the
Yeah.
motion?
Go ahead, Commissioner Glenn.
This is for a motion for recess session. I move that the commission recess this open meeting with conflict counsel Jesse Burris present to discuss matters related to confidential investigations pursuant to KSA 254165 and KSA 254161, and for good cause as provided by KAR 1962. Justification for recess is so the commission can exercise quasi judicial functions when deliberating matters related to said confidential investigations as contemplated by KSA 754318 G1. The open meeting shall be resumed here at 3:05 p.m.
Great. Do I have a second?
Second.
Motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion signify by saying aye.
Aye.
Dean?
Turn the live stream back on for you.
What if we say 20?
Okay,
We'll probably sit idle for a little bit, but
3:20.
Well, if anybody needs a restroom break or something.
Better 3 minutes of idle than going back in for 3 minutes, right?
Yeah.
I don't know, maybe you disagree.
no.
3 minutes either way.
All right, you're live.
okay, I believe, I need a commissioner to make a motion to, enter into recess session again until 3:20. Do any commissioners wish to make that motion?
I can't, everybody's looking. You know, it's gone last time. What'd you guys go? I'm just kidding.
We didn't have one.
I
Sat
move,
here in silence.
I move that the commission recess this open meeting with conflict counsel Jesse Burris present to discuss matters related to confidential investigations pursuant to KSA 254165 and KSA 254161, and for good cause as provided by KAR 1962. Justification for recess is so the commission can exercise quasi judicial function when deliberating matters related to said confidential investigations as contemplated by KSA 754318 G1. The open meeting shall be resumed here at 3:20 p.m.
Great. Do I have a second?
A second.
Motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion to return to recess session signify by saying aye.
Aye.
Yes. Thank you. You're welcome. I was telling people the wrong.
We are live.
Work Wednesday then.
Okay, returning to open session, Commissioner Berger, I believe you have some motions or yeah.
I'll do it as 2 different motions as the humble and obedient scrivener for the recess session. I would move that complaints 795, 800, and 801 be dismissed without prejudice, and that 796, 797, 798, and 799 be found to be sufficient.
Second.
Motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion signify by saying aye.
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 All opposed say nay. The motion passes.
With regard to probable cause determinations on behalf of the commission, that complaint 791 be found to show probable cause, that 792 be dismissed, and as for 794, that count 1 be dismissed, but that count 2 show probable cause.
Second.
Motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion signify by saying aye.
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 All opposed say nay. The The motion passes. Any further comments? Motions? Do we need a motion to designate hearing officers, or do we simply say that for the record?
The chairman appoints the hearing officers.
Okay. So Commissioner Ramirez will serve as hearing officer in complaint 791, and Commissioner Clausen will serve as hearing officer for complaint 794. And I know that we have a couple other hearings designated for our January meeting, so we will defer to staff on whether or not we have the bandwidth in that meeting to have the hearings then, or if those will need to take place in February.
What is, okay, we have, go to the combined one that we continued today.
Okay.
And we have 790. on-
Correct.
Yes.
No, 790
Sorry.
in
Yes.
January.
Okay.
Then we've got two additional with 791 and 790.
I think we need to, because the other two I think will be disputed, I think we need to move those to the February meeting.
Okay.
The two-
The 791 and 794.
So when is our February meeting?
Apologies. The 26th.
Okay, so we will set complaints 791 and 794 for February 26th. Returning to the agenda, I think all that we have to do is just note that our next meeting will take place in 9 weeks on January 22nd, 2025. Do we have any other matters to discuss?
Just as a matter of process, or when there are instances when something gets resolved, at least between the complainant and the respondent, once it reaches the public hearing stage, I'd like us to think about having 3 different documents that are submitted. One being a stipulation of facts executed by the respondent as a true stipulation, and actually both parties as both a recommendation for what those parties have agreed to recommend to the commission, and then the findings of fact and conclusions of law that may incorporate those things, but that the commission would be free to diverge from.
I have a question of
Yeah.
how to best do that, because essentially what we're having in these consent decrees is a settlement. So they're only admitting liability under the condition that we agree to other facts with them. And so I'm
Well,
struggling.
you don't bind us though. That's the thing. So I don't want them, I don't want them to go into this thinking that those facts aren't facts if we don't agree to a particular outcome. They're either facts or they're not. That's what I'm thinking. They're either facts or they're not facts.
But I'm struggling to understand if both parties agree that these are the facts. You're saying the commission can just independently ignore what the I'm not saying
Absolutely.
that was poor verbiage. I don't mean it that way. Of
No,
course,
I
the
didn't take it.
commission
I
has-
didn't take it in an offensive way. I'd say that if there's something to be worked out, that's for the sufficiency and the probable cause levels. Once we reach the public hearing, it's a public hearing and the commission has full authority to exercise whatever judgment that it's going to exercise.
I guess may I request if we have something such as the election sensitive guidance document that is very specific, because in those instances, we would have normally dismissed the complaint
Right.
once it had been filed.
Mhm.
But because and I understand in the 788 was different, but in those instances, the complaint would have normally been dismissed once the report was filed. But because we had a guidance document in place, we could not do that, but we didn't need a full blown hearing
Right.
because the parties agree. So in that, I guess that's a little different, but.
Yeah, I don't think we really have as much, I don't want to call it discretion,
Mhm.
but as much independent judgment to exercise that.
And that's kind of my question, is in those unique instances, what we presented for Mr. Bargdill, for instance.
Well,
The single,
I think we're just fortunate that it kind of works out, but in the realm of sitting in a quasi judicial role, if I don't have those facts as being stipulated, then I need you to introduce them and we need to make those findings.
I guess for me, I want to make sure that what we're doing is promoting an action, promoting judicial autonomy, basically. That
Exactly.
I think that we have, I think that the idea is good, but I'm worried that when it's played out, we have scenarios where we might have a matter where the commission could ultimately determine this is a really bad violation and could be up to $10,000 in fines. But it would be pretty drag out slugfest of trying to prove the actual facts, or we can settle it for $500,000. And we can we have separate stipulated facts that removes that entire ability to settle the matter, because they're not going to sign stipulated facts without it being attached to an amount.
And again, respectfully, if it is something the commission believes to be that serious, then the commission needs to treat it that seriously, regardless of what arrangement you reach.
Well, you would be able to reject the consent decree, but then essentially we'd have to prove the case then, right?
So I think what the executive director is trying to say is that our concern is creating too many different documents moving in different places, because we already have a lot of pleadings going on. And I think the concern is the goal in the consent decree is they are stipulating to those facts. That's the point of the consent decree. And I did agree with suggestions you made earlier that the additional clarity can be added and future consent decrees will continue to improve.
Yeah.
But I think the concern is having multiple documents when we could do it in one singular document that the commission either can reject or can accept.
Because the commission can reject it and say, we don't think this is an appropriate settlement, just like a judge can. But then we have a case or we dismiss it. I mean, I think that'd be the way that'd be my interpretation of.
Right. I hear what you're saying. You've heard my opinion on it and the process from where I think that I sit in that particular role. And I mean, act accordingly.
I think we'll learn as we go through, all of us, what works best. So it's a work in progress.
I think in some of these matters, we can do that because I don't think that, for example, I don't think Mr. Schmidt was likely to, he probably would have signed a separate stipulated facts of a paid-for violation, right? But if we have a very complicated matter, that may not be the case. We may have a conditional stipulation, basically, which is what we really did here, more in line with the traditional settlement or plea bargain.
But it's all, everything is noted and taken into account, made note, that to be considered.
Yeah, and it's a good discussion. And if anyone else has comments, please say what you're thinking, because we want to make sure that, I mean, we're staff, we're here to support the commission. So if you want to see things in a certain way, let us know so we can figure out how to best support what you want to see.
Yeah, and we've got a couple examples of the consent decrees and orders that were relevant in today's hearings. And so I think that's a good starting point to take a look at those and say substantively, what is it that they're missing that we could add? I think that would be productive, but Commissioner Berger, perhaps we just revisit the idea at our next meeting and see what kind of measure of progress we can make.
Yeah, and I put it out there for everybody to think about and chew on as you fill the role of the hearing officer and as the, deliberator and see what functions from our position. And we're all, those officers free to do as they wish, right? Just we're there to facilitate the commission.
If everyone agrees on what should happen in a matter, we want to make it as easy as possible for us to have the hearing happen the way it is. So I think we're all on the same page in our goals, which is good.
Appreciate the brainstorming.
That's good.
Anything else we need to discuss before we adjourn? If not, I'll take a motion to adjourn. Motion has been made. It has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion to adjourn signify by saying aye.
Aye.
All opposed say nay. The motion passes. This adjourns the November 20th meeting of the Kansas Governmental Ethics Commission. Thank you, everyone, for your attendance, for your diligence in working through all the materials and preparing all the materials, and staff, thank you. It's a great meeting. We'll see everybody in 9 weeks. I hope everybody has a very enjoyable holiday season. And we'll look forward to seeing you on the other side of the year.
Yep.
All right. Yeah.
All right.
Bye.
That's right. Thanks, everyone.
Absolutely.
Take care.
Thank you all.
Bye.
That's just 2000. Yep.